Ma'am, can you explain to us exactly what the situation is here? This man did not attend my wedding. I specifically invited him. He also refused to pay the cash gift I requested, and I need him cited and removed from this community for conduct unbecoming a resident. Ma'am, you called 911 because your neighbor didn't show up to your wedding. It was not just a wedding. It was a community meeting. HOA President Penelope Vance showed up at the front door of 4412 Magnolia Blossom Way. She told the homeowner directly that his failure to attend her wedding was unacceptable. She claimed his refusal to pay the $5,000 cash gift she had expected had resulted in $6,800 in violation fines. These fines were accumulated against his deed. They were fines she had personally generated using bylaw sections that did not exist in the Plantation Ridge Estate's governing documents. She warned that if the balance was not cleared within 30 days, she would file a lien. She threatened to go to the county recorder's office and begin foreclosure proceedings. She said all of this with the confidence of a woman who genuinely believed that skipping her wedding was a punishable offense under HOA law. What she didn't know was that the homeowner had recorded every single conversation since she first demanded the $5,000. His attorney had already identified her demand as a textbook extortion attempt under state law. The lawsuit being prepared against her was going to put her demands and fines in front of a judge. Her wedding invitation, conditions, and 11 years of HOA misconduct were going to be reviewed by a judge who would not find any of it amusing. Julian Sterling, 43, a senior financial analyst for a wealth management firm based in Charleston, lived at 4412 Magnolia Blossom Way. He had been in the Plantation Ridge Estate's gated community of Mount Pleasant, South Carolina for 4 years. Plantation Ridge Estates sat in Charleston County, one of the most affluent counties in the state. The entrance gate had a staffed booth, and homes started at over $1 million. The HOA dues were steep enough that residents expected them to actually mean something. Julian had bought his property after a decade of building his career. He had renovated the kitchen and master suite in his first year without a single complaint from anyone on the street. He was the kind of neighbor people liked without having to think about it. He was quiet, professional, and completely unbothered by what anyone else was doing with their property. He was checking his mail at the end of his driveway on a Saturday morning in early spring when he found the wedding invitation. It had been placed in every single mailbox on Magnolia Blossom Way. It was not mailed through the post office, but hand-delivered by Penelope Vance herself. This told Julian everything he needed to know about how seriously she was taking this event. Penelope Vance, 54, had been HOA president for 11 consecutive years. She had spent most of that time making her personal preferences indistinguishable from the actual bylaws. She was getting married for the second time to a retired developer named Arthur. She had decided that her wedding was a neighborhood event, whether the neighborhood agreed or not. The invitation specified a strict dress code. It demanded formal attire only, with absolutely no exceptions. It included a gift registry at 2 upscale Charleston retailers. It also demanded a cash gift minimum of $5,000 per household. She had printed this on the invitation in bold, without any apparent awareness of how that would read to the people receiving it. Julian read the invitation twice, set it on his kitchen counter, and decided he had other plans that weekend. Before we go further, what city or country are you watching from? Drop it in the comments. We love seeing exactly where you're tuning in from. And if you believe that no HOA president has the right to fine a homeowner for skipping her wedding, hit that like and subscribe button and join us here on Care and Conflict. Penelope's wedding took place on a beautiful Saturday in late April at a luxury venue on Kiowa Island. Julian stayed home, watched a game, and did not think about it once. He had no obligation to attend a private event, and he had made no promise to anyone that he would. When Monday morning came, he went to work the same way he always did, and considered the matter closed. Penelope did not consider it closed. She appeared at his front door for days after the wedding. she was still carrying the energy of someone who had been thinking about his empty seat all week. She told him his absence had been noticed by everyone in attendance. She claimed it had been disrespectful to her and to the community, and that the neighborhood would be talking about it. Julian listened to everything she said while standing in his own doorway. Then he told her politely that he had prior commitments that weekend and wished her well in her new marriage. Penelope told him that was not good enough. Then she made the specific offer that changed absolutely everything. She told him that if he paid her the $5,000 cash gift she had specified on the invitation, she would consider the matter settled and move on. She said it clearly and directly. She wanted $5,000 in exchange for her letting the issue go. Julian looked at her for a long moment and told her he would not be paying anything. Penelope told him he would deeply regret that decision and left his porch without saying another word. The first violation notice arrived in his mailbox just 6 days later. It cited an unapproved exterior modification. It was a potted plant Julian had placed near his front door. Penelope claimed it violated Section 3.2 of the Architectural Guidelines. The fine was $400. Julian pulled up Section 3.2 that evening. He found it contained no language restricting potted plants of any kind anywhere on a residential property. He photographed the notice, photographed the bylaw, and put both in a secure folder on his desk. The second notice came for days after that. This one cited a vehicle parked in his driveway at an angle that allegedly violated HOA parking standards under Section 7.4. The fine was an astonishing $600. Section 7.4 covered guest parking in common areas and had absolutely nothing to do with a homeowner's private driveway. Julian simply added it to the folder. Over the following 3 weeks, 7 more notices arrived at 4412 Magnolia Blossom Way. They were invented infractions and misquoted sections, with fines ranging from $250 to $900 each. The total accumulated against his deed reached $6,800. Julian did not pay a single dollar of it. He documented every notice and cross-referenced every cited bylaw. He also recorded 2 separate conversations with Penelope. In these recordings, he referenced the wedding and the unpaid $5,000 in the exact same breath as the fines. She connected them in her own words, without appearing to understand what that connection would look like to a judge. He called his attorney on a Thursday evening and brought the full folder. Julian's attorney reviewed the folder in one sitting. She called it one of the cleaner cases of HOA harassment and attempted extortion she had seen in 15 years of practice in Charleston County. Every single fine was fabricated. Every bylaw citation was either misquoted or completely invented. The recorded conversations where Penelope connected the fines directly to the wedding gift demand were incredibly damaging. It was the kind of evidence that does not require much explanation in a courtroom. The attorney told Julian they were not just looking at a simple HOA dispute. They were looking at extortion under South Carolina Code 1617640, and she wanted to move very fast. Penelope moved first. She called the Mount Pleasant Police Department and reported Julian. She described his actions as ongoing willful noncompliance with HOA enforcement orders. 2 officers arrived at 4412 Magnolia Blossom Way on a Tuesday afternoon. Julian invited them in, sat them at his kitchen table, and walked them through the folder. He showed them every notice, every bylaw comparison, and both recorded conversations where Penelope had offered to drop the fines in exchange for $5,000. The officers listened to the recordings twice. They left without making an arrest and filed an incident report that noted absolutely no criminal violation had occurred on Julian's part. They did carefully note the specific content of the recordings in their official report. Penelope filed her civil lawsuit the following week, seeking recovery of the full $6,800. She also sought a court order compelling Julian's compliance with future HOA enforcement actions. Her filing cited section after section of the Plantation Ridge Estates bylaws. They were the exact same sections Julian had already documented as misquoted or entirely non-existent. Julian's attorney filed the counter-lawsuit just 4 days later. It was 53 pages long, and it named Penelope Vance personally and the Plantation Ridge Estates HOA Board as a collective body. It cited severe harassment, fabricated violation notices, abuse of HOA authority, and attempted extortion. Attached to the filing as Exhibit A and Exhibit B were the 2 recorded conversations. It was Penelope's own voice connecting the fines to the wedding gift demand in language that left absolutely nothing open to interpretation. The board received their copy on a Friday morning. By Friday afternoon, 2 board members had already called their personal attorneys. The case was heard in Charleston County Circuit Court, and it did not go well for Penelope from the very first day. Her attorney attempted to argue that the violation notices were legitimate enforcement actions taken independently of any personal dispute. That argument collapsed the exact moment the judge listened to the audio recordings. It was Penelope's own voice, calm, direct, and completely unaware of how it would sound in a courtroom. Connecting every fine to the $5,000 wedding gift demand she had never received was not something any attorney could explain away with bylaw citations. The judge did not need long to reach a decision. Every single violation notice was declared legally unenforceable. The $6,800 in accumulated fines was dismissed in full. The court found in favor of Julian on the harassment claim. They ordered Penelope to pay his full legal fees, plus massive punitive damages. The judgment described the damages as compensation for a sustained and deliberate campaign of financial intimidation. The extortion finding was entered into the public record. It was permanently logged in the Charleston County Circuit Court, where it would remain attached to Penelope Vance's name for anyone who cared to search it. The Plantation Ridge Estates HOA Board removed Penelope from the presidency by unanimous vote the same week the judgment was handed down. They commissioned an independent audit of every violation notice she had issued during her 11-year tenure. The audit found a massive pattern of fabricated enforcement actions going back further than anyone on the board had been willing to acknowledge. For residents who had paid fines under similar circumstances, filed their own legal actions in the months that followed. Penelope Vance listed her home at 4418 Magnolia Blossom Way. It was the house she lived in when she decided a man owed her $5,000 for skipping her wedding. It went on the market 8 months after the judgment. She sold it well below the asking price and left Mount Pleasant without making an announcement to anyone on the street. Julian Sterling checked his mailbox on the morning after the judgment was entered and found absolutely nothing in it. It was exactly the way he liked it. If this story reminded you that the moment someone tries to use a title to take money that was never theirs, they have already lost, share this video with someone who needs it today. And if you have ever been fined, threatened, or pressured by an HOA president who made it personal, drop your story in the comments because every single one deserves to be told. See you on the next one, right here on Karen Conflict.